Hello everyone. This is week 1 of our subject dispute resolution and crisis incident management. So our learning objectives is for us to discuss the significance of the alternative dispute resolution and comprehend the wisdom of the alternative dispute resolution system. So they say that we here in the Philippines are very fortunate in terms of justice system and processes. Why? Because we are allowed by law and by customs to choose from different options to resolve our conflicts. So it can be observed that the three sets of justice system, namely, first is the barangay justice system, which admits or serve as an alternative justice for easy or summary resolution of disputes. However, when a resolution was not met, then it can pass on to the regular or mainstream justice process after a certification of non-resolution passed by the barangay lupon. So kapag walang napag napagkasunduan, no, na solusyon ng problema, then that is the time na pwede nang i-elevate yung conflict or kaso sa uh, court. Okay? Pero as it was as I have said, there must be a certification of non-resolution na gagawin ng barangay lupon. Attesting there na there is no resolution being agreed by both parties. Another distinct justice system that we have here in the Philippines is the existence of several tribal or indigenous justice system which the Law on Indigenous Peoples' Rights Act recognized as binding agreement of parties in dispute. We can also glean that our Philippine justice system is both restorative and retributive, no? In the sense that it allows resolution of disputes by parties through mediation and arbitration, where claims and penalties can be waived or lessened depending on the agreement of the parties in dispute. Under the spirit of the alternative dispute resolution, the parties will make amends with their conflict and come again as close friends na parang walang nangyari. Our justice system may be considered as retributive as gleaned from the regular or mainstream justice system where all crimes have corresponding penalties attached to it as a means of preparation and retribution to the affected party. Nevertheless, within the regular process, there are stages where it allows the dispute to be resolved amicably. So these are manifestation of restorative processes. So let us start with the definition of alternative dispute resolution. This is a means of settling disputes outside of the courtroom, hindi po sa korte. It includes early neutral evaluation, kung yung conflict ba ay hindi naman masyadong serious or grabe. Negotiation, conciliation, mediation, and arbitration. So, alternative dispute resolution was devised to uh, declog or lessen court backlogs. No? It will also help the person involved in a certain dispute or conflict in the high cost of litigation. So, um, magastos po kapag may kaso, no? Pag nag-file ka ng kaso sa korte, of course, aside from your time, uh, gagastos ka rin, no? And this is one of the reason why this alternative dispute resolution system was conceived. The most common forms of alternative dispute resolution are arbitration and mediation. However, negotiation is almost always attempted first to resolve a dispute. So, negotiation is the preeminent mode of dispute resolution. Negotiation allows the parties to meet in order to settle a dispute. The main advantage of this form of dispute settlement is that it allows the parties themselves to control the process and the solution. So, mediation is an informal alternative to litigation. Mediation is a procedure in which parties, uh, the aggrieved party and the offender, discuss their disputes with the assistance of a trained, impartial person. So we call that mediator, no? Who who assist them in reaching settlement. Mediation is also, uh, as I've said a while ago, an informal alternative to litigation. So this is with the assistance of a mediator. Mediator are individuals trained in negotiations. So they help opposing parties together and attempt to work out a settlement or agreement which will be accepted or rejected by the parties. So mediation nowadays is used for a wide range of case types already, ranging from juvenile felonies to national government negotiations. So lalo na kung ang mga uh, persons involved ay mga kabataan. Now let us talk about the act which created alternative dispute resolution system. And this is Republic Act 9285, which is known as the Alternative Dispute Resolution Act of 2004. So this is an act that institutionalized the use of an alternative dispute resolution system in the Philippines. We will have some of the pertinent provisions of the ADR law. So under Chapter 1, Section 2, it emphasizes the uh, use of alternative dispute resolution as an important means to achieve speedy and impartial justice and declog court dockets. So we have mentioned that already a while ago. And chapter 2, we have here, it covers the process of mediation. Under section 9, uh, we have here the confidentiality of information obtained through mediation proceedings. So what are the principles and guidelines behind the confidentiality of information that was obtained through mediation? So, information obtained through mediation shall be privileged and confidential. Privileged in the sense that only a person authorized to have access of the information uh, will be allowed to have access of it. Okay? A party, a mediator, or a non-party participant may refuse to disclose and may prevent any other person from disclosing a mediation communication. In an adversarial proceeding, the following persons involved or previously involved in a mediation may not be compelled to disclose confidential information obtained during mediation. So ang mga taong ito ay hindi uh, mapipilit, no, na magbigay kaalaman sa mga impormasyon na, na narinig niya, no, during the mediation period. So, unang-una, yung dalawang party, yung aggrieved party and the victim. And then, the mediator or mediators, the counsel for the parties, the non-party participant, any person hired or engaged in connection with the mediation who acted as secretary, stenographer, clerk, or assistant, and any other person who obtains or possesses confidential information by reason of his or her profession. Okay, so there is the term counsel there a while ago. So counsel, of course, will refer to lawyers. Are lawyers required or allowed to be present during mediation? Um, Typically, mediation situations do not require the parties to obtain their own legal counsel. Kasi nga, mediation is designed to help people work through conflicts without the need of a judge or legal proceedings. However, uh, lawyers can be present. This is upon the discretion of the mediation officer. No? But the role of the lawyer will be as an advisor and consultant. No? So, yun lang po yung role niya. Now let us proceed to enforcement of mediated settlement agreement. So ito na po yung application or enforcement doon sa napagkasunduan, no? During mediation, kung ano yung solusyon na dapat gawin. So the mediation shall be guided by the following operative principles. A settlement agreement following successful mediation shall be prepared by the parties with the assistance of their respective counsel, if any, and by the mediator. The parties in the respective counsels shall endeavor to make the terms and conditions thereof complete and make adequate provisions for the contingency of breach to avoid conflicting interpretations of the agreement. The parties in the respective councils, if any, shall sign the settlement agreement, and the mediator shall certify that he or she explained the contents of the settlement agreement to the parties in a language known to them. So, no kalinggada, dapat maipaliwanag di kay content ti settlement agreement kanya da iti Ilocano. No kalinggada, Kalingano. Ilocano, Ilocano. If the parties so desire, they may deposit such settlement agreement with the appropriate clerk of a regional trial court of the place where one of the parties resides. Where there is a need to enforce the settlement agreement, a petition may be filed by any of the parties with the same court, in which case the court shall proceed summarily to hear the petition in accordance with such rules of procedure as may be promulgated by the Supreme Court. Okay? So, dito kasi, di ba, this is happening in some amicable settlement, no? Wherein the aggrieved party and the offender came into agreement. So, after that, it is expected for the offender to comply with the agreement settled between them, uh, between them of the victim. Pero ang nangyayari kung minsan, pagkatapos ng settlement, nawawala na yung offender. That's why this is a very important part kung saan yung settlement agreement ay pwedeng i-deposit, no, with the appropriate clerk of a regional trial court kung saan nakatira ang isa sa mga uh, parties involved. Of course, siguro yung victim. Kasi kapag mangyari man yung ganon, ito, where there is a need to enforce the settlement agreement, magpa-file ng petition, no, yung aggrieved party to the court. Okay? Para matulungan siya na ma-enforce yung settlement agreement. Okay? So, our lessons end here. For your activity, for all activities in all your lessons, you can find it on the last part of the module. No? So you have there, it is titled requirements. So you have several activity. Sometimes under this lesson, you have only one activity, which is a case study. So there are case situations which are presented here, and then you are going to answer it by applying the principles that we have discussed in the lesson. You can also refer to the suggested reading for additional input. Okay? So, may I remind everybody that if you are coming here in school during Thursdays, because that is the schedule of submission and release of modules, you already leave behind the module. Do not bring it with you. Sa inyo po yung module, no? So, ang gagawin ninyo, you will file that in separate folders per subject. So that kapag kumpleto, kasi you will be having uh, lessons 1 or week 1 to week 17. For your prelim, you have week 1 to week 5 lessons, and for your midterm, you have week 7 to 11 lessons, and for your final, you have week 13 to 17 lessons. So that will complete the module. And if you're going to keep it by folders, uh, you keep it na neatly so that you will have references in the future, okay, for your review materials. So this is all, and thank you for uh, joining me. Hope to be with you again. Hope you join me again next uh, video. Thank you.